Hi, my name is Ted Smith. I'm an attorney and I practice in the area of Social Security disability law. And I want to talk today about 6 mistakes to avoid when appealing a denial of Social Security disability benefits. So the first mistake that I see all the time is that people give up without appealing. They just don't. They file an application for disability benefits. They wait 2 or 3 months. They go out for examinations. They get all the records are obtained by Social Security, and then they get a denial letter. And when they get that denial letter, they just set it down, walk away, and they don't try to appeal. That's a huge mistake because on an initial application, about 30% of the people get disability benefits while 70% don't. But the next stage is not any better, and that's about 4% of the people get disability benefits and about 96% don't. But the stage after that, which is the hearing stage before an administrative law judge, the stakes are much, much better. And it's like 50-50. It's about 50% of the people get disability, 50% don't. It's the best shot in the whole system to get disability benefits, assuming your medical records prove that you're disabled. So you can't give up. You have to continue to pursue the appeals. It's frustrating and it's time consuming, but that's just what you have to do. So that's first mistake. So the second mistake to avoid is failing to hire an attorney because you think you can't afford to hire one. That's just not true. It is possible to hire an attorney. Most attorneys work on what they call a contingency fee basis. That means that you don't have to pay an attorney unless you get back benefits, and then those fees are regulated by Social Security. And if you don't get any back benefits, assuming that's what you agree to with the attorney, you don't have to pay an attorney. Sometimes you have to pay for copies of medical records, but that's the only thing you'll have to do. So it's really important not to go on with your appeal just because you haven't gotten an attorney. So the third mistake to avoid when appealing a denial on Social Security disability case is waiting for the last minute to hire an attorney. Attorneys can help you win your case. They can develop the case, they can get the medical records that are necessary for the judge to look at the case and to decide in your favor. They can help prepare you, and they can help prepare all the documents that are needed to submit to the judge in order for the judge to get a really clear picture of what's going on. And in addition, most lawyers write pre-hearing briefs, which summarizes all your medical records and your argument. And if you wait to the last minute, you don't give that lawyer a really good chance to help you. So it's best to hire the lawyer as soon as you get denied and let the lawyer work with you to give you your best shot at winning the case. The fourth mistake I see is people giving up on treatment. And what happens is that they start to go to a treatment, they don't get better, and they get frustrated because they're not getting better, and then they just stop treating. In mental health cases, for depression, for anxiety, for PTSD, people treat for a while and then they stop treating. And what I hear the reason they stop treating is really because treating in therapy, I understand, is very difficult to do. Therapy's hard, it's hard work, but they stop, they don't like it, and they just don't want to talk about things. But if you give up on that type of treatment, you're not going to be able to show the judge what's going on with you. And that's not enough just for you to tell them. The therapist and the psychiatrist or the psychologist has to help the judge better understand what you're going through. And the only way that can happen is if you treat. Similarly, if you have a pain case and you're advised to go to pain management and you don't want to go to pain management and you just try to deal with it on your own, that's not going to help you. It may make you worse, and it's also not going to give the judge an understanding of what's going on with you. So you need to continue on. Even though it's hard to treat, you need to continue to treat with your healthcare providers. The fifth mistake that I see is not recording your symptoms. And really, this type of problem has to do with headaches, and has to do with seizures in the most part. Pain journal is very important, but headaches and seizures are even more important. And the reason why is because part of Social Security looks at your case with about the frequency you have with headaches and the frequency you have with seizures. And I guarantee you that if you don't keep a journal for both or either one of those, you will not remember when you go into the hearing room how many headaches you have in a day or a week or a month, or how many seizures you've had in a day, in a week, or a month. And those numbers are very important. And to say, well, I get them all the time, it's just not going to be enough for the administrative law judge. You have to really document that. And with regard to pain, people say, I hurt all over all the time. And that's the extent of their pain testimony. And that's really because they don't keep a journal of their pain issues, about what's going on and what's hard for them to do. So it doesn't take much. You should keep pain journal. You should keep a headache journal. You should keep a seizure journal, and then give those journals, or at least a copy of it, to your providers, to your healthcare providers, so they can know what's going on, so they can also better treat you. And then that becomes part of your medical record as well. The sixth mistake to avoid is saying too little at your hearing. And that means that you get nervous and you want it to be over quick. And so you just sort of give 1 or 2 word answers instead of really talking about what's been going on with you for years and why you can't work. The hearing is the time to give your side of the story to the judge, because this is the first time in the whole system of appealing disability cases that you've had that you have an opportunity to tell your side of the story to another person. And you really have to be prepared to talk about that in detail and answer the questions in detail about what is asked of you. And if you do that, you have a lot better chance of winning your case. So in recap, you don't want to give up with your case without filing an appeal. You should hire an attorney and do away with the idea of the expense thing. Make sure you have a clear understanding about what your contract is, but you should try to hire an attorney. You should not wait until the last minute to hire an attorney because you want that attorney to help you develop your case. You should continue to treat and follow your doctor's advice about everything and do exactly what the doctor says. You should keep a journal for your symptoms, including headaches, pain, and seizures. And then when you get to the hearing, you should tell the judge in detail about your condition so he or she can understand what you're going through. So if you have any questions, please don't hesitate to contact me. My name is Ted Smith. You can reach me at 1-800-296-2290 or text me at 765-644-8410. Thanks.